the relief here, pending a decision of the Constitutional Court on the validity of that act of conduct. That's why it's important where we started, because where we started, remember I say it's a 172.1, but I'm saying assume that I'm wrong. Court is constitutionally empowered. Temporary relief in the form of Section 18, pending a decision of the Constitutional Court on the validity of that act of conduct, if they are correct. Their interpretation of the orders, which we dispute. But I'm at pains to go into this debate on the assumption that they are correct in their characterization of the order. I've told you the reasons, this honorable court, of the reasons why I differ with their characterization. But I'm saying throw that all to the dustbin and say that yes, what we're dealing with here is so-called ancillary order or whatever. But it's and it's whatever. That's the answer. It lies in 172.
So it's a very important point that you are making, Mr. Mbofu, and I think we just need to
clear it a little bit. Yes.
So you are content to determine the matter on the basis 172 to apply.
I'm not that.
That's why I want to.
No, okay. Let me explain myself. Yeah. I'm assistance to the by doing that. I'm not going to as much as I'd like to assist the court. I have to stay on my course. I'm saying, Justice, let me summarize it. I'm saying the orders must be read separately. The order in 187.6 is a self-standing order for the reasons I've explained. And I say that order derives, among others, from the common law finding made by this court. And that's crucial, because this court did make the finding of actual bias and
maybe I phrased my question clumsily.
Yes.
I think the applicant's case is still as stated in the papers. But if you're saying that if you are wrong on that,
I'm prepared. I'm saying even, yes, in fact, that's a better way. So even if I'm wrong on all those things, I'm saying then 172.2b. In other words, even if I'm wrong in everything I've said, 172.2b was designed for exactly this situation that we find ourselves in. Let's assume this court had said, Justice No, explicitly, which it didn't, by the way, and that goes to 500 awareness point. Let's assume the court had said, setting aside the suspension, another order. This order of setting aside up here is cannot be implemented until there are confirmation proceedings. Let's assume the court had said that. Unlike what the court actually did, which was to say it's effective now. And that's why I agree with my learned friend's point. Because this court didn't keep quiet on the question. It answered the question. But I'm saying, let's assume it answered it against us and said, no, it's not in September. It should be effective in November or whatever the confirmation proceedings. Let's assume that was so. We, in terms of Section 172.2b, justices, we would have been entitled to come here, right, and say, yes, we know that this is what you said, but here are the exceptional circumstances, what have you, and so on and so on. Please, other interim relief in the 18 and 18, and you say yes or no. That's exactly the purpose of Section 172.2b. Unless if anybody is going to say, well, we didn't do that. If you had said specifically, this order shall not be implemented until such time that it's confirmed by the Constitutional Court, we would still be entitled in terms of 172.2b to come here and say, yes, we heard you. However, the public protector, whatever the facts are. And you would have to evaluate those facts. If you like them, you grant us the relief. If you don't like them, you deny us the relief, and everyone will be happy. So it's a waste of time, this whole, it's just smoke and mirrors, this whole 172 thing. It's a red, really has nothing to do with the application before us. The third issue, which, if this doesn't put it plainly beyond any doubt, then is the following. We know that what has happened in real life is that the DA and the president have, well, the president simply copied what the DA was doing. Well, let's just use one example. So what the DA did was to file hurriedly. Let's leave all those things about whether they did it hurriedly or not. Let's assume that they did it after 15 days. But what did they do? They filed a notice of appeal and what? Alternatively, notice of application for leave to appeal. Common cause. Right? Now, what? And again, we've said those notices are not genuine, they don't make all the necessary allegations. In fact, they are not properly before the court. For example, the Section 19 application is supposed to state why you're not going to the SCA and going straight to the Constitutional Court. They didn't do anything with that because they were just rushing. So they left out all the requirements of Section 19. But again, today, let's assume that it applies, assume that it complies, assume everything is perfect that they did. Well, let's go to the source, Section 18. Because I'm at pains to make sure that this court is not waylaid into or fancy footwork, which is really all this is. This is just all this is an attempt, a very clumsy attempt to resuspend the public protector. This time he being resuspended by the DA instead of the president. But let's see. But even if you do that, you must do it properly. So being, and I apologize for doing this. I'm now doing it for different purposes. The last words. Section 18. Subject to subsection 2 and 3, and unless the court under exceptional circumstances otherwise orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or for an appeal is suspended pending the decision of the application or appeal. So, if there is an application for leave to appeal or an appeal, that's exactly what they have done. They have filed an application for leave to appeal or an appeal. So, in which world then is what they have done? So, they can't say what they have done suspends the judgment. And in the same breath, say that Section 18 doesn't apply. Where's the logic in that? Because the real reason we know they did what they did was not for the love of justice. It was to secure a suspension of the order. But so they want to have their cake and eat it. So they want a situation where they do something with the aim of suspending the order. But what the law provides as an antidote for that thing that they've done, which is Section 18.1, must not apply. That's like wanting to fight somebody in a boxing ring, but they must be, their hands must be tied at the back so that they can't hit you back, basically. That's what they're doing. Because how can you have it both ways? How can you have it both ways?
As I understand, what they seem to be saying is that the effect of noting an appeal or applying for leave to appeal in respect of an order which is subject to confirmation, it does not suspend because that order is incoherent.
Good. If that's what they're saying, then I'm going home right now. Because if that is true, then we're dealing with an incoherent order. We're dealing with an order which is a final order. Then what are we doing here? Because that situation is covered in section 18(2) of the Superior Courts Act. It says subject to substance unless the court under exceptional circumstances orders otherwise. The operation and execution of a decision that is an interlocutory order not having final effect of a final judgment, which is the subject of an application for leave to appeal or an appeal, is not suspended pending the decision of the application or appeal.
No, but then they say that that scenario does not apply here because here what applies is section 172(2)(b. So the applicant could only come to court to say there is this incoherent order, but I can't wait. So I seek this interim relief or interim interdict, and that applicant is not done.
That's true. That's what we're doing here. I'm busy doing it right now.
They say you have come under section 18, which does not apply. It's section 18 of the Superior Courts Act. But in these circumstances, you could only come under section 172(2)(b. But I'm just putting that.
No. I understand. That's why I'm saying
so that we
yes,
can engage with it.
I accept that, but that's the absurdity of the argument. Because they're saying we should come here under 172(2)(b. And I'm saying here, we're here under 172(2)(b to seek other temporary relief. So that's why I'm so indulgent on this argument. Because if they are right in all of that, then I'm saying you have to then say two things. This court would have to make something dramatic. It would have to say that the words other temporary relief in 172(2)(b do not include a section 18 application. I don't know on what basis you can say that, but it would have to say that first. Secondly, it would have to say the words appeal and application for leave to appeal in section 18 do not include the appeal that they have put. I mean, so in other words, you'd have to say the words appeal in section 18 have a qualification that we all don't know in the whole country. That actually you have to rewrite section 18. The court would have to rewrite section 18 and say which is the subject of an application for leave to appeal or an appeal, except for an appeal that is brought under section 172 by the DA and the president. I don't know, something like that. You'd have to rewrite the section. In other words, you'd have to qualify the words appeal and leave to appeal. Because an appeal is an appeal. That's what they've done. They have appealed, right? So the section 8, whether you look at it from the point of view of section 18 or look at it from the point of view of 172, you come to the same result, which is that if you look at it from 172 point of the vintage point, then you say this is exactly the temporary relief is what we're seeking here. If you look at it from the point of view of section 18, then you say the word appeal means appeal. And what did they do? They appealed.
But didn't they appeal? So
I'm sorry.
the DA appeal to the Constitution?
Yes.
Up to this court. So how can one use an appeal lodged in the Constitutional Court? Justifying keeping it together.
But there's no appeal here.
There is no appeal on the basis of no appeal.
Yeah.
Before us.
Yes, there's no appeal. That's not up here. Let's just be clear. There's no appeal here. There's no appeal in the SCA. There's just an appeal which they have, according to their logic, lodged in the Constitutional Court. That, Justice Francis, is exactly what is envisaged in 172B, if you read it A. Right? What does A say? It says the thing must be confirmed not by this court, but by the Constitutional Court. Right? Then you must go to 172.2D to clarify that question. 172.2D is the answer. It says, any person or organ of state with a sufficient interest may appeal, or underline the word appeal, or apply directly to the Constitutional Court to confirm or vary an order of constitutional invalidity by a court, which means this court, in terms of this subsection. In other words, the empowering section that allows them to lodge the appeal is 172.2D, on the basis they are any person or organ of state with a sufficient interest. For present purposes, they are a party, so they're a party. So the point I'm making, Justice Francis, is the following, and that's why it's there's no jurisdiction issue. When we come here, let's say, for example, they were appealing to the SCA, right? Which they would have to do because this is from a full court. And then just the right thing, not this stuff that they did. Let's say they did the right thing and say on day 15 or whenever. We're not happy with this judgment, we're appealing it in the SCA. Then what must we do if we want it to be executed? We can't go to the SCA, we have to come here and say, in terms of section 18, this court must give us a section 18 order. Now, you can't then say, no, but they are in the SCA or the Constitutional Court or the Court of International Justice. It doesn't matter. The point is, an appeal is an appeal. The effect, and that, unfortunately, I don't know if the Tassima case, if I may actually just hand up some of our authorities, unfortunately, they are this morning from Johannesburg, so I'm not looked at them. Not this one. Somewhere there, and again, to save time, is the Department of Transport versus Tassima. You'll find it's page 95 of that bundle of authorities. You'll see there's a discussion. I think it starts from paragraph 2. I want for the court with it. It's up to 40, up to about 50, where the court discusses the Clameza case, one of the leading SCA cases on this. Yes. Let's go to paragraph 49. This is what the Constitutional Court said. It is, sorry. Yes, it is now appropriate to revert to a consideration of the import of section 183, section 18.3 of the Superior Court Act.
Sorry, paragraph, what paragraph?
49, my lord.
49, yes.
Page 101 of that panel we just
I've got it.
So, but what this court is called upon to determine in the context of this case is the import of 18.3. In particular, this aspect of the case raises the question whether an order made under 18.3 retains its legal force beyond the date of the decision of the appeal that finally determines the dispute between the protagonists. To answer this question, it is necessary to emphasize the point that all the subsections of 18 are interlinked and therefore to be read contextually. Let me just pause then. The conventional wisdom, which is correct, which was set out by Justice Francis in Incoherence and confirmed by the Constitutional Court here, is that if once you get the Section 18 order in the lowest court possible, the one that made the decision, let's say it was a single judge, the purpose is to suspend that order, and the appellant can go all the way. They can go, let's say, to the full bench here. If it was one judge, it's still suspended. Go to the SCA, it's still suspended. Go to the Constitutional Court, it's still suspended. Why? Because an appeal is an appeal. So if the section says it is suspended pending an application for leave to appeal for an appeal. So it doesn't matter where that appeal happens to play itself out, as it were. That's the import of what the Constitutional Court was saying. It goes on, but I'll try and save time. If necessary, I'll deal with it in the plan. But so there's no issue really, whether it's in the Constitutional Court or the SCA and so on. In fact, that's where, by the definition, when it's called an appeal, it means it's in a higher court. It can be an appeal from the same level. So by definition, an appeal is in a higher court. So okay, let's just then go back to the point I was making. In fact, I think I'm done because as I said, let's keep the eye on the ball. What is the ball? Does Section 18, is there any, let me put it in the negative, is there any reason that we can think of why Section 18 does not apply, or why Section 18 is excluded from the other interim relief that is envisaged in 172(2)(b? The answer to that is simply no. And as I said, you can look at it again from the other side. Is there any qualification to the word appeal or leave to appeal in Section 18? And the answer is no. And I'm happy for the court to look at it from whichever vintage point, because the result is exactly the same. So the Section 18 applies, there's no doubt about it. The only, if I were I'm not here to give them free legal advice, but what they could be saying is to say that when the court grants the relief, if the court says we're granting it with section in terms of 172(2)(a) to be read with Section 18, as we are saying, then they can say, well, it must be pending the confirmation proceedings and so on. That if I was them, that would be that argument, but it's not the one that is made here. So I'm not going to waste time on it. Yeah, so the question of applicability of Section 18 is very clear. Let's now go into the merits. And you see, this matter, you have to look at it in its true perspective. The reason why we are distracted with this gymnastics about whether Section 18 applies and so on is simply because there is no answer to the Section 18 application. And I will demonstrate that now. The actual Section 18 application, for all intents and purposes, is unopposed. And I will explain that, and I'm not exaggerating. Because they had no answer to the actual Section 18 application, they had to find all these fancy That's why we say in our head, clever by a half. The 172 argument is clever by a half because you just dig yourself into the hole of the actual interpretation of 172 and section 18. Now, why is this? Why am I saying it's unopposed? Right, this court, I'm not going to bore the court by dealing with the test in detail, except to say this. I've learned this dealing with section 18. In fact, one of my opponents, let me say, learned it the hard way because they pleaded only what I call the statutory requirements, the 3 statutory requirements. And this was a matter that involved some mining matter. I'm digressing into it for a purpose. And as the court knows, so we had succeeded in the one judge, and then they appealed under the automatic appeal provision. And then they went on exceptional circumstances, no irreparable harm, and irreparable harm on the other side. And all we needed to do was to go to the, I think it was Justice Park, was presiding, was simply to say, well, yes, those are the 3 requirements. The courts have now infused a 4th requirement, effectively, which is the issue of prospects of success. And the court said, where have you pleaded that? And they pleaded it, and that was the end of it. I'm saying that in aid of the following. Forget the statute for now. Well, don't forget it, but read it together with the rest of the law. You might remember that when this was still section 18 was regarded as a novel invention back in 2013, 2014, because we had just migrated from the South Cape case and Rule 4911. And one can never understand this without always going back. And 11. And our, okay, I want letters of 19. But I was talking about this regarding the essence of what Section 18 is about. Section 18 is a departure. The only thing really that Section 18 has done is to depart from what we all used to do until 2013, which was to go to court and say we must do a balance of harm. You remember that expression? It was called balance of irreparable harm. So prior to by the legislature, you had to come to the court, this court, and say that I'm going to suffer if you don't grant this is more than the harm that the other side will suffer. Right? The legislature intervened decisively. So we no longer, that's spelled out in Kemeza, spelled out in AfriForum, it's spelled out even in Tassima. We no longer do a weighing exercise. The legislature has done is now to separate the test. You have to prove that you will suffer harm, and you have to prove on the balance of probabilities that the other litigant will suffer no harm. So it's there's no weighing exercise anymore. It's this one will, in Clemens actually is underlined, in SNAPSA JA, underlines the word will and will not. And that is what we know in the business as the heightened test. That's really all that has happened. It has now therefore introduced the heightened test on the part of, because why is that so? Because it has an ordinary fourth position is that the winner must wait, basically. And I explained this to my daughter, who's not even a lawyer, and she understood it. To say that if we're fighting about a pen, then I win, and the pen is supposed to come to me. And you put in an application for leave to appeal. If you had the pen, then you say, oh, well, I'm keeping the pen until the appeal. Why is that so? It's for a good reason. Because what would be the point of giving it to me, and then I use it and I write and I finish it, then you win some appeal a year later. So the law, the default position is that it must stay where it is until the appeal is. But I said to her, if I can go to the court and demonstrate that there are exceptional circumstances, that I will suffer harm if I don't get the pen now, and you, because you have a house, but for me that's my only pen. Then the court will say, okay, you Mr. Boff, you can have it. That's all really. That is all. So the default position, all the law said is that this default position must be departed from, not so much after the so-called weighing exercise, but the test is higher now. I must show harm on my side and no harm on the other side. That's all. So where are we then? Taking it back to this case. We have said, and if the court wants us to, again, I don't want to waste the time of the court, but if there is a case that has exceptional circumstances, it is the raw state power has, according to this court, abused that power, acted improperly, actual bias, also reasonably apprehended bias, also a breach of section 96(2), because this involved his personal interest. That's what we have here. Now, we are told that those circumstances are just, usual. It's, this happens every day.
But wasn't the argument that the exceptionality of the circumstances must be relevant to why it is that the default position must be departed from?
No. Well, firstly, I don't know where that comes from. But yes, that was the argument. But the argument is very simple. That the law, at least, is very simple. That and it is what we have put in as a preamble in our head, so that it's clear. And this is the relevant, or how relative, or maybe I'll call it that. So this statement has been endorsed by all the courts from Sutherland J in Incubator. It says, necessarily, in my view, exceptionality must be fact specific. Okay, that's the first thing. The circumstances which are or may be exceptional must be derived from the actual predicaments in which the given litigants find themselves. Who are the given litigants? It's the Public Protector, the DA, the President. The primary, actually the primary litigants now is the President and the Public Protector. The other parties have joined on one side or the other. Really, it's just now we've got the tail wagging the dog, so to speak. But that's a story for another day. So the actual litigants, for the purposes of this, again, let's assume that the DA is the primary litigant. All that is said here, Justice Nubu, is that the exceptionality must be relative to them. And I'm saying, I'm talking about one of those litigants called the President, right? And I'm saying what has been found here, just dealing with the issue of exceptionality, I'm saying that it is the most exceptional thing to happen. We have said in the founding affidavit, this case is even more exceptional, to use that word, than the EFF Nkandla case, which it follows. And when we say that, we're saying it's a tool of analysis. So we're saying, for example, if you think that the Nkandla circumstances were exceptional, then it's not logically possible to think that these circumstances are not exceptional, because these are 10 times worse than what was found. I've already alluded to the fact that Nkandla was only about the low threshold in section 96.2. There's no finding of actual bias there. There's no finding of impropriety. There's no finding of effectively malafides, an improper motive or ulterior motive. It was simply an appearance, a risk of conflict is sufficient. It doesn't even have to materialize. Here we have the worst end of the spectrum. If this is a scale of 1 to 10, Nkandla is at 1 or 2. This case is at 10. Full throttle. Because it's got everything. What more can you be guilty of? 96.2, apprehension of bias, actual bias, ulterior motive, bad faith, and abusing the state machinery. And I'm saying this, let me make this statement, and I'm making it boldly. This case involves abuse of state power. Nobody in their right mind can dispute that statement. But what kind of abuse of state power? It is the kind of abuse of state power which amounts to the highest form of corruption. Because there's this notion that this case does not involve corruption. When you abuse state power, whether you are taking a bribe as a traffic police person, or giving a tender to the wrong person, or suspending the person who is supposed to investigate you, all of those people are doing exactly the same thing, justices. They are abusing power that we gave them as citizens for personal gain. That personal gain might be 100 rand in the traffic cops example, might be $1 million in the tender person, and it might be whatever amount it is here in the Pala situation. If you don't believe me, you must believe the Constitutional Court. Because this is what the Constitutional Court said in the United Democratic Movement versus Speaker of the National Assembly, 2017-5, okay, they've got the wrong one. It says SAZACC at paragraph 6 and 7. I'll give you the law report citation. I think it's 2017-3 SA, page 300 CC. But the if that is not the correct citation, I'll give it now. This is what, in that case, I hope this time Mr. Badlander will not forget, because he was my junior in that matter. This is what the Constitutional Court said. This is the so-called secret ballot case, which we did in the Constitutional Court. And it explained the linkage between abuse of power, abuse of resources, state resources, power that you have been given in that office, and what I call effectively corruption. This is one of the most profound statements ever made in our courts against this kind of corruption. And it was directed at the President. You'll find that, my lords, at page 12 of our heads, paragraph 45. And I'm going to read it slowly because it's the heart of what I was saying. The President is an indispensable actor in the proper governance of our Republic. and bearing important constitutional responsibilities. Then I jump some parts. Then it says public office in any of the three arms comes with a lot of power. That power comes with responsibilities whose magnitude ordinarily determines the allocation of resources, money, for the performance of public functions. The powers and resources assigned of each of the arms do not belong to the public bearer of the office. Sorry, there's that protector there is wrong. Public bearers who occupy positions of high authority therein. Let me just repeat that. The powers and resources assigned to each of the arms do not belong to the public office bearers who occupy positions of a high authority therein. They are therefore not to be used at the advancement of personal or sectarian interests. Amandla awethu, manda ndiashu, matlak ya rona, or matimba ya yina. Power belongs to us. And maibuye Africa, restore Africa and its wealth, are much more than mere excitement-generating slogans. They convey a very profound reality that state power, the land, and its wealth all belong to we, the people, united in our diversity. These servants of the people, are supposed to exercise the power and control these enormous resources at the beck and call of the people. What the Constitutional Court was saying there is that if you are given power to be the license giver, the tender giver, or the traffic police person, that power does not belong to you. It is state power. And it comes with resources that we all invest to make you the president or whatever office you hold. And we put millions of money and prestige and all that around that office. That power should only be used for its intended purpose. Once you use it for personal gain, you are stealing our money, right? You are taking away what we said. We are giving you 100 million rand so that you can grow some forests or whatever it is. And you take that 100 million rand and you use it for personal gain. That is theft and corruption. That's what this passage is. Now, if that is not exceptional, even when it is performed by the highest office in the land, well, then we can all go home and it's fine. Then we'll accept that.
But how does that answer the question as to why can't the applicant wait until the appeal is determined? Okay. Because I think that's the critical question.
Let me come to that. Okay, let's take your word, Justice Nugu, wait, right?
I borrowed it from you from an example about the pen. And
I'm taking it back. I'm saying, let's share it. Wait where? That's because that then touches on the issue of harm, Justice Nugu, as well. Wait where? She must wait in the condition of being suspended. That's where she must wait. She must wait in the degrading and undignified position of her dignity being vilified. She must wait where her reputational rights are being infringed. She must wait where her right to work and practice her profession and occupation is being taken away from her. That's where she must wait. And the point I was making, Justice Nobu, because I was coming to that, is that who is this person who must wait? It is the person who is the victim of the most egregious abuse of power ever seen in this republic. That's and we say, no, it's fine, she must wait. And the person who says she must wait is the person who put her in that position. So effectively, what we are then saying is that the victim of the abuse that I've just described now, of the corruption, of the theft of public money, the target of that abuse of the highest form of state power must wait.
Right, Mr. Mpofu, we are going to take a tea adjournment. May I ask that during that tea break, you now amongst yourselves as to until what time so that
Yes.
we can then work?
We will do so. How long is the break?
We'll reconvene at 11:30.
As court is.
Court to that, yeah.
I've got the five, the three and the five, the pages. Okay. But, un poco a me.
Volume 2, right? It must be this one. Yeah.
For each one of them.
Yeah,
No. Shares on both.
That's the only thing I've ever been. Okay, where is that? Oh, the legislation. Okay. E1 is short. Okay. Where's the bundle? Where's the bundle of authority? Yeah, this one. Okay, from that way to two. Okay. Thanks. Sorry. Oh yes. So this is our set. Guys, supposed to do.
Hey, what was that?
Yeah, at least for one. That's a good one. I like that. If you put it like that. What's the 7? Sorry, guys. Remember, they asked us to talk about it. Are you ready? Well, I don't even know how much long. Because I'm eating more on the mind that time.
How long do you need?
You don't agree on 30 each, but I'll be, I shouldn't be anything close to 50.
Because it's covered.
Probably.
Give him the compliment at this point.
No, you don't.
Yeah, some of these I have to say. Between 20 and 30.
Okay, no, let's do it the other way around. Only because I was not timing myself. On the allocated time, where are we now?
So at 9:30.
No, it's 10. It's not 10.
Well, after the intervention,
Yeah.
Oh, you mean after? Okay.
I think you've had an hour and a half, because I think you started just before 10.
I started at 10. Yeah, well, okay, 5 to 10.
Yeah, then you've had an hour and a quarter.
Then it's an hour and a quarter. Okay, of the 3 hours. So I'm going to try, okay, please, when I make 2 hours, just indicate. Because then I'll be eating into your time.
45 minutes.
Because then I'll be eating into the young's time. But I don't want, I want to eat a little bit. That's all. I don't want to eat everything. Okay, so you're saying 20. So it's really giving me 10, but look at that guy. So he doesn't know.
Still one more time.
Yeah. Why don't you follow a good example of me?
How much more time do you realistically need now? Okay.
I don't know.
Yes, I can.
Yeah, now to cover three areas.
And that should say, there is no intervention like that. That's your own devices.
No, we're not going to. It should take about an hour.
Another hour. So we're going to go to lunch.
No, what's the time now? What's the hour? So one of you will be done then. One, whoever goes first. Who's going to go first?
I'll go first. But look, I'm not going to do timekeeping. I'm just going to go and argue when you finish.
No, but what I don't, quite frankly, if I eat into your time, I eat into it. I don't want to eat into their time. And I don't want to force you to eat into their time.
I've never done that in my phone.
I didn't say high profitability.
The judgment ordered that as of the day that the judgment was actually handed down, he then had to proceed to go back to the office for the court of 2 hours to know that the Democratic side of appeal to effectively suspend that judgment by the Supreme High Court today and on the Public Protector why they actually want to determine regardless of the appeal, not only by the Democratic line, but also interesting to hear today advocates of the Public Protector essentially saying that what the Democratic Alliance has done in the appeal process is essentially resuspend the Public Protector.
Exactly.
See, that's what I mean. Just more discipline.
So it is.
No, you actually assuming. Yeah. Yeah. Are they coming?
No.
No.
Beverly? I'm so sorry if you took offense. I'm sorry if you took offense.
No, that was it.
But she came and specifically, she started talking to me.
Yeah. Okay.
After lunch?
So much because it's a toilet. I've got standing notes on it. No. But I'm not going to work with you if it's standing. But I must find it this weekend. Just try
Great. Let's be green. Get a great comparison. We want to take that one. Yeah, this is huge.
Yeah, please. No, me, I'm using this one. And then, the constitution. I'm fine with it. In fact, I was even desperate for that one. When I couldn't find them. I said,
Yeah, you just touch the thing and it comes out.
Yo, I almost missed my flight.
doesn't tell me anything. I haven't had any contact of his team. So,
I think if I arrived 2 minutes
because you start 9 o'clock.
And you can't take a charge of public, right?
And so I'm going to the country on yesterday before, and I'll come at 6:15. Okay.
the black mamba.
The black mamba.
The black mamba. It's like
Which one do you want? The black one or this one? Because it's a convenience.
no, this one is how it belongs to we the people.
Have you seen that one?
I can give them back. I think I'm going That's matter.
It does matter there.
That's why it's a black You guys can have your white constitution.
You may proceed, Mr. Buffer.
Thank you.
I understand that there might be load shedding around 2. I don't know what we are going to do if that happens, but perhaps we'll see.
Yes. Thank you. Well, I'm going to I just want to round off this issue of exceptional circumstances. What I'm saying is and I'm responding directly to the question you raised just now. When we look at exceptional circumstances, according to the formulation of Sutherland J, we must look at what he calls the actual predicaments of the litigants. So the actual, and that's why I'm saying this overlaps fortunately with the harm issue. So I don't have to repeat the submissions. But the predicament of these litigants is what when we took the lunch, rather the tea break I was talking about. The predicament of the public protector is that
these allegations before this court, in that there was never a disciplinary hearing and neither invited in any disciplinary hearing.
In 1 week, in the circumstances that I described, where all she has ever done was to do her work, according to the judgment at least. The thing that put her in that position is that she was discharging her duties to investigate without fear, favor, or prejudice. In a nutshell, that's all. So that's her predicament. Then let's look at the predicament of the DA. I don't know what it is, I'm sure we'll be told. The only predicament of the DA is vindictiveness and vengeance and hatred and all those. Because the DA has already had, as you said, the history of the matter is that Advocate Mkhwebane. And to the extent of having the court can take judicial notice of the fact that when the announcement was made of the suspension on the 9th of June, the leader of the DA was on national television saying that they are popping champagne. And the reason they were popping champagne is because they are the complainant, coming to the facts of this case. They are the so-called complainant that brought about the Section 194 committee, which in turn has brought about.
He took 35,000 rand from Makwe, he took 27,000 rand from Mabena, he took 5,500 from Mofokeng. The list is just endless. Therefore, this court is satisfied that there is
conflicted. Their interest is a perverse interest to ensure the oppression of a black woman whose only sin is to do her work. So we have to accept that as the starting point. And then we say, no, fine, let's leave it like that. Let's leave matters exactly where they are. So that in the next 3 months, in fact, up to the point, one can only speculate. Remember the so-called presidential minute, Justice, says that
no, there was just a note to say that there's a court which might not be affected by
load shedding. Okay.
Load shedding, but I don't know if the logistics will permit.
Yes, hopefully, yes. Okay, but at least we know there's a plan B. So the point I was making was that the DA's interest, apart from the perverse interest of just wanting to see the public protector suffer, is that as I said, as a complainant in the Section 194 committee, they are necessarily conflicted. And in fairness to them, they accept that in their papers. They say that it was the DA that brought the Section 194 committee proceedings. There's no other interest. They don't claim any shame. They don't. They just say it's all the other South Africans and what have you. Well, the law is very clear. The predicament of the litigants. Yeah. So that's where you start. Of course, I'm not going to stand here and say, if you have a predicament as a litigant, you can't then say, well, in any event, that also affects the wider society and what have you. But that can be the only thing you're bringing here to the table. To say the starting point, what is the predicament of the DA and the harm that they will suffer? Zero. But if they had some, and then they say, well, on top of that, you can also look at this one and that one and that one, then it would be understandable. Zero, zilch. So this is the classical... Isn't that
oversimplifying it, Mr. Mpofu, because in their papers, they seem to suggest that her going back to the office might have impact on the witnesses who might testify.
Yeah.
And this is a matter that has not been dealt with on the substantive reasons for her suspension.
Yeah. Yes. Let's assume that is so. What is their interest? I'm saying well, firstly, that only confirms what I'm talking about when I talk about the perverse interest. Because when they say that, Justice Nugu, they are confirming exactly what we're saying, that they want to suspend her. Because what you've just told me now, those are reasons for suspension. Interference, classical reasons for suspending a person is interfering with witnesses or the evidence and so on. So in what world are we going to give the Democratic Alliance the power which the Constitution decided exclusively lies to the President of suspending for the reasons that you just mentioned? They can't. Neither the Democratic Alliance, and with the greatest respect, this court has the power to suspend the public protector for whatever reason. Doesn't matter. Let's say she's going to go there and shoot everyone or whatever. The Constitution has decided. If she's
going to go there and shoot, that might well be a reason why she should wait until.
No, I'm making a different point. you know.
No, I'm saying that lightheartedly.
No, I understand. I'm saying that let's assume she's going to do that. Okay, it's the classical what they say in the streets. So what are they going to do about it? It is not for the Democratic Alliance. It would be, even in that situation where she's going to go and shoot everybody, the only person constitutionally empowered to intervene is the president of the country. There's a reason why the Constitution did that. There's a reason why the court itself cannot do it, or the person next door, or the inspector of whatever. There's only one person constitutionally empowered. So if this court is going to allow the DA to suspend because it feels that she's going to interfere with witnesses, that's an insult to this court. Because this court, with everything that they've said, made a decision that the suspension must be set aside with immediate effect. But no, the DA says no, but what about, there's no parking there or whatnot. So it's the DA now that must decide what happens to her. Well, that's wrong. As I say, not even the court is empowered to do that. So it's not simplifying it, Justice Mo. I'm asking a very simple question. What is the harm that the Democratic Alliance will suffer if the order is granted? There is none. Okay. Now, and I was saying that this is the classical case that was envisaged by the drafters of Section 18 of a situation where the losing litigant has no harm that will befall it, and the victorious litigant has obvious harm. And that's why I'm conflating, I know, the issue of exceptional circumstances, because these issues are related with the issue of harm as well, so that we can save time. So I'm saying that apart from the exceptional circumstances, which I would have thought speak for themselves and which I've spelled out of this particular case, there is patent harm to anybody, by the way. It doesn't have to be the public protector. I gave this court cases that show that that come from the statement that says suspension is the employment equivalent of arrest. That statement is very profound, because what it means is, we as lawyers maybe know about arrest more. Arrest is prima facie harmful, right? So a suspension is prima facie harmful to you, because it affects your reputational rights, it affects your dignity. I gave the case of Maseka. Justice Sachs said that an incumbent does not live by bread alone. So the fact that the person is getting paid is neither here nor there. It is what goes with the office. I gave you the case of Wachenuka, Home Affairs versus Wachenuka. The judgment of Justice Nugent, who said in paragraph 27 of that a human worth, self-worth, is work is about self-worth. I gave you the case of it's Northwest, I think it's it's one of the cases we cited previously, where this thing about suspension being the equivalent of arrest comes from. So, it would be so cynical to ask somebody who's being suspended that what harm are you suffering? You should just fine. You are on holiday. Because our courts, I'm sure, are not that insensitive. And the fact that there is no harm on the other side just makes the question, the point very clear. As we speak, the public protector is watching all this from a sick bed because of her health. She would otherwise have been here. But she doesn't want to be neither on her sick bed or here. She wants to be where she was, the job she was appointed to do by the people of South Africa, which is to protect them. And therefore, that's the situation where you can act for the wider harm, because you must first show the harm to yourself. And then you say, then there's also harm to the office, then there's also harm to the public, which we again would hope that would be self-evident in this situation. Quite apart from the fact that, as I say, the court has made a decision, correctly so, in my respectful submission, that a victim of this kind of abuse must the effect must be immediate. Now remember this, I said this the last time. In our law, the only reason that this court did not give an order of retrospectivity, and we support that, by the way, of this court, was because, as courts usually do, I think it has happened in the DPP cases. So they say, okay, this DPP was not rightly appointed or whatever. Then they can't say, well, it's a retrospective effect, because that means all the criminals who have been prosecuted will say, well, we were prosecuted by the wrong person. So this court did the right thing, but it must not detract from what it means, an order of constitutional invalidity. I explained it. An order of constitutional invalidity does not go back to the date of suspension, ordinarily. It goes back to 1996, when the Constitution was passed. That's how it, otherwise it nullifies, it's like there was no suspension. It did not happen, constitutionally speaking. So that's where we are. We know what that means. If, to go back to our example, Justice Smith, it turns out that tomorrow the public protector is going to shoot everybody. All this court has said, it didn't say then she must never be suspended, lawfully so. No. It says if she's going to be suspended, it must be a suspension that is lawful. In other words, by a person who's not conflicted, who doesn't have an improper motive. So we can't exaggerate a situation A that has not happened, or B that if it happens as if we will be helpless. We won't. The issue that we want to undo is the effect. Let me put it this way. What you are being asked to do by them is to basically resuspend her, but through the DA. Now what is going to suspend her, instead of using a letter of suspension, he uses something called a notice of application for leave to appeal. It's the same thing. That's all they want. The DA, again, to his credit, if I can use that, says so in its letter, the letter to us on that day. Remember what they say, Justice. They start by saying 172. We tell them, no, it doesn't apply. A few hours later, they put the notice of application for leave to appeal. And then BDA BMDA 4, page 104. Then the truth comes out. They write at, let's say, 3 o'clock. The judgment comes at 2:30. 3 or something past 3, they write to us and tell us the story of 172. An hour later, we write to them. We say, no, that's you've misread the law. And then this is what they write to us in the evening at 1:04. If your client is correct and the High Court order is not subject to confirmation by the Constitutional Court, the High Court order is in any event suspended by our client's application for leave to appeal. And paragraph 5 shows the real motives. In the circumstances, whomever is correct, the High Court order is not presently operative and your client's suspension from the position of public protector remains effective. That is the purpose of this entire exercise. That's why we're here. Maybe it was a slip of the tongue, but they made it clear here that the so-called appeal is just a route to paragraph 5, which is your client's suspension from work. That's what they're doing. And if we allow them, anybody really, to abuse the law to that extent, by clothing them with powers that they don't have of suspending a person who has been unsuspended, quote unquote, by the court, then we will deserve to have a banana republic where people can just do, use clear subterfuge, very clear, undisguised, where they say themselves in their own words. This is not me, this is them saying it, to achieve nefarious ends. So none of these parties are here with clean hands. They are conflicted. They have they're abusing this expression called abuse of court. When we explain it to students, we explain it in simple terms. Abuse of the court process means this: using the machinery of the courts not for the purposes that it was intended. So you use Section 18 not for the purposes that it was intended, but you use it to resuspend a person, as they are saying here. That's classical abuse of the court process. But as if that is not enough, in the case of the DA, they then come here and, in line with what Justice Nogo is saying about witnesses and what have you, they come here and seek to deceive the court. They give 400 pages, I think. This record has got 9 volumes now. Half of volume 7, and yes, up to the things that should not be before this court. It's just obfuscation. They give you those hundreds of pages of so-called evidence that's happening in the Section 194 committee. This is the urgent court. And you give 400, 500 pages of irrelevant stuff, and then they apologized yesterday for doing so. Now, let me tell you where the deception is there. That is supposedly evidence. Let's assume it was relevant for a minute, which it is not. It's evidence, affidavits of some of the witnesses who have given evidence in the Section 194 committee. Just their affidavits. The fact that they've been cross-examined, some of those statements have been retracted or contradicted and so on. No, you're not given. You're just given the raw statement as if that is all you have. If they really wanted to inform this court about what's happening in the 194 committee, they would have given you the record and say, this is the record. Witness number 1 said this. This was the cross-examination. This is what happened. Witness number 2. No. They come here in motion court and simply give you the unadulterated version. That shows again the perverse interest that we're talking about. And I want to say this. If the court stands by and allows itself to be abused like this, firstly, this is a waste of valuable judicial resources. The fact that we're here for some simulated so-called appeal, which is a fake appeal. It's not a real appeal. It's just something make-believe. And then in that process, we are then saddled with hundreds and hundreds of irrelevancies. And what I call clever points which take us nowhere, then we have something coming. So let's move then quickly to the last point, which is prospects of success. Now, here we have summarized the position. Because of this rushed job, maybe, they again have shot themselves in the foot. Because all that has been done, really, they just say, okay, the court was wrong to find that there was no reasonable apprehension of harm. That's called a ground of appeal. How can, where are they saying there are prospects of success because there is this or that law, or the court misdirected itself, or did not read this document or that document in terms of the Zumayo test or whatever? No, because there's no such thing. This court has said something very profound. I think it's at paragraph 155 or 157. That there is no other plausible explanation for the conduct of the president other than the fact that he was abusing his office. He was abusing the power that we gave him as South Africans to be the president and therefore be the person who is mentioned in section 194.3 to shield himself away from the investigation of his Pala scandal. That's all. So where we should be getting an analysis that say, no, the court got it all wrong. So there are prospects of success because here's the plausible explanation. This and that and that. But the reason why that is not done is because it does not exist. There is nobody in their right mind who can find a plausible explanation for this. That there's a judgment which is coming. Let's say, for example, he didn't know that it was coming on the 10th. Knowing that there's a judgment that is coming imminently, soon. Knowing that there are undertakings, and I know the court made its own findings on that, knowing that there's an undertaking that might suffer whatever defects the court found, but there's an undertaking nevertheless that we will give you some pre-warning of the suspension. Knowing all that, and then you get being a party to the litigation. It's not like some other person who's not a party. You are a party to this litigation. You have been all along. You yourself have said that if that conflict ever arises, I will delegate it to somebody else. And knowing all that, you issue. And the president says the following. I mean, honestly, he says, I did not know that the judgment is coming tomorrow. And let's grant him that. So I went to the assembly, I addressed the assembly, and only then did I learn, because of some coincidence, the 1434 effect, as we said. The court here issued the thing at 1434 and the letter also came out at 1434. Let's assume all that is coincidence. But this is what he's saying to the court with a straight face. When I realized in the afternoon, when I finished in the National Assembly, that the judgment is coming tomorrow, the following day, I just went to bed. Who does that? How could let's think about the President of the United States, or even here, where there's capital punishment. Let's say the President, our President, let's say we still have capital punishment. He says, I've signed the letter of execution for the person. I signed it at 3 o'clock. I didn't know that there's new evidence. I went into Parliament, but at 6 o'clock when I came out, I was told that, no, that is the wrong person. It's not the person who killed. The real killer has confessed. And he says, well, I've signed the letter. There's nothing I'm going to do. Kill him. That's what we're being told, that even when he discovered afterwards, he didn't have it in himself as a human being to say, oh, well, if the judgment is coming tomorrow, I'm withdrawing my letter or whatever it is, and I'll reissue it after the judgment. Just out of respect of the courts, if nothing else. Don't worry about respecting the public protector. Just out of respect of the courts to say, I'm withdrawing the letter, I did not know, genuinely did not know, and we will see what the court says tomorrow. If the court says I can suspend, I will suspend. If it says I can't, I won't. No. He said, let's watch the news or whatever. Now, this is we are told that on those facts, there's a prospect that another court can find what? That on his own version that he knew after the National Assembly address and did nothing about it. That on his own version, not forget about us, write us off. On his own version, he, by that one single act of omission, would he have done that if he had the Ubuntu and the empathy to know that this suspension is going to befall all the consequences and go on for 3 months and so on?
But then was he not functus officio after the letter was issued?
No, yeah, Justice Lekulen, you know, there's a nice Latin terms, functus officio. But we must never entrap ourselves in those things. Because technically, the rule of functus officio is defined in this book that Mr. Bishop agreed that he'll give it to me when I need it. Administrative Law in South Africa, Cora Hoekstra and Penfold, as this. Once a decision maker has made a decision, a court, let's use the court. Yeah. Once the court has made a decision, that's it. There's nothing you can do about it. And it is the origin of, for example, Rule 42. The first words you will get in the commentary on Rule 42 will be about the functus officio rule. It says it's a D1-561 of Erasmus. The general well-established rule, and the point I'm really making is that we have all these general rules with nice sounding titles, but they all have exceptions to cater for the kind of thing I'm talking about. So the general well-established rule is that once a court has duly pronounced a final judgment or order, it has itself no authority to set it aside or correct, alter, or supplement it. The reasons for are twofold. The court becomes functus officio, and its authority over the subject matter ceases. Secondly, the principle of finality in litigation expressed in the maxim interes re publicae ut sit finis litum, in the public interest that litigation be brought to finality. And then it says, that's exactly why we have Rule 42. So that in certain circumstances where you are able to show that despite the functus officio rule, the outcome is going to be oppressive if the court, the very same court that said, we're done, goodbye, comes back and says, we will listen to you, because legal rules are about justice, not just about mechanical application. So imagine who would have said, I think, speaking as a citizen now, everyone would have said, what a great president we have. Nobody would have said, but what about the functus officio rule? If he said, I came out, my office didn't tell me, in the evening I discovered that the court, a court of law, you know, a full court is going to give judgment tomorrow on this very thing that I was intending to do. And I'm saying I'm withdrawing the letter, and the judgment was at 8 a.m. or something. At 10 o'clock, I will make an announcement one way or the other, depending on what the court says. No, if then we say no, the Functis Officio rule, ketile. No. That would have been the proper responsible thing to do, and it would have been the opposite of a breach of Section 96(2), and it would have demonstrated the exact opposite. So what am I saying? I'm saying that there is no prospect, and that I'm deliberately using the president's version, because I can come here and tell you about our version. You know our version. You know our version is that this whole thing was just a pala hit back and so on. I don't want to go there. I'm saying use their own version. You can't change the facts. That's one thing we know as lawyers. When you go on appeal, you can't change. The record is the record. And the record says that he became aware of it on the 9th in the afternoon on his version. So the prospects of success, with the greatest respect, are zero. Particularly on the question of reasonable apprehension of harm. Reasonable apprehension of bias. So let's say all our theories are wrong. Because remember, we say it's actual bias. We say he knew and he did it deliberately. Assume we're wrong. Who can say that there's no reasonable apprehension of bias for his failure to act overnight? Who can say that the breach of Section 96(2) did not happen where the threshold is lower than low? The threshold in 96(2) is that if there's a risk of a conflict, you must not act. And the EFF Nkandla case says that risk doesn't even have to materialize. So all you have to say is, what will people say if they know that I've got these 31 questions from this person and I'm now about to suspend them and there's a judgment that is coming? What will people say? They might be wrong, those people. They might be crazy. But what will it look like? That's perception, reasonable perception. To a reasonable person, what will this thing that I'm going to do to this person look like? So there's no issue. And by the way, this issue of prospects of success was not done, it was not added by the courts to amend the legislation. The legislation still has the 3 elements. But again, like everything in law, the courts were saying, look, we can't just be abused. You can't just say, when, the court says the sky is blue, and then you say, I'm appealing. And then they say, okay, for the purposes of the appeal, the sky will be red. So it was meant for those kinds of absurd cases where the court could, it basically was entitling the court to say, no, but we know you filed a notice of appeal, but it's so hopeless. It's, no, there's no court that's ever going to say the sky is not blue. So it's meant for those. Otherwise, the statutory requirements remain the statutory requirements. They are onerous enough on their own. But we accept that the courts have added this, and we don't quibble with that. You'll remember that Justice Sutherland originally said the issue of prospects of success does not come into it at all. But Justice Binsward in this division found differently in the Justice Alliance case, and the SCA in AfriForum and Kemeza found that, and this division, with the greatest respect, has been leading in this area of law in that respect. And I've taken the liberty in my head to refer to the judgment in Eitzach, which is also in Erasmus, which took the matter further and said that you can, even if you are the loser in an interim order, you can still invoke Section 18. And the reason I put it there is because the judge who made that profound decision was none other than a certain Masuku A.J. So there has been great developments in the. So what Acting Judge Masuku was explaining was a purposive interpretation, that the purpose of this thing is to protect litigants. So we mustn't mire it in technicalities, but and that's another great contribution from this division in this area of law. Let me deal quickly with the question of costs, and I'll deal with it again in reply. But in fairness, so that my learned friends can respond. Let's take the big picture. What's the big picture? The big picture is that we have been brought here by, the irony is this: the underlying problem with the judgment, or rather with the conduct of the president, was the hurried nature of his suspension, which was clearly intended to run away from accountability. We are back there right now. We have another hurried suspension, quote unquote, or resuspension by the DA. One can ask the following question rhetorically, hopefully, so that it doesn't need an answer. The Democratic Alliance assumed this was a confirmation process. Two things should happen. One, if it was a 172.2 matter, then the law says in Rule 16 that the registrar of this court must take that order and submit it at the Constitutional Court. So why did they not wait for that? Rule 16 says that in 15 days they can appeal. So why did they not wait for that? Why did they have to do it in 3 or 4 hours? Why? And do a shoddy job at it of not even complying with the section. There can only be one answer to borrow the words of this court. There is no other plausible explanation for that hurried activity of the DA, apart from what they say in paragraph 5 of their own letter, which is to revive the suspension. So the courts must not allow this kind of thing. We would implore this court to mulct these respondents with punitive costs. And we don't say this lightly. Justice Madlanga said in the case of the Public Protector versus the South African, the Commissioner, fashionable, I'm paraphrasing, to mulct the Public Protector with punitive costs, personal costs, and so on. And the basis, for example, and he said that this must stop. And he said the one case in which the Constitutional Court had endorsed such an order was the Reserve Bank case, SARB versus 2019 volume 6, page. Oh, by the way, the reference to the UDM case, I just got the volume wrong. It is 2017-5, not 3, SA, and the page was correct, 300 CC. But so what Justice Madanga was saying is that it should not be so easy to mulct the Public Protector with costs. And the justification that was given were two, the bias and unreasonableness. Now here, and actually I'm glad I've thought about this so that I can make this point. We've alluded, for example, to a cross appeal which might come from us. We ourselves are aggrieved by the judgments of this court, by the way. And that's why we are talking about the possibility of cross appeal, in respect particularly of the interpretation of Section 194(3)A, and this issue I was talking about of the interpretation of the agreement between us as counsel and all that. Many issues, the sub judice rule, or what have you. But on the assume, let's say it was us that were appealing now. according to this interpretation, that should suspend. We should do that appeal and then run away from the office, as it were. These are some of the absurdities of this case. But I'm making that point to say that to the extent that there might be a cross appeal, which we're very confident about, by the way, on some of the other points, that even makes the case for the possibility of the prospects of success even bigger. Because if we have any prospects of success, let's say around the question of the interpretation or whether there was a removal committee and so on, then that makes the situation even better for us in the sense that we now have prospects of success. They have prospects of losing again, even on a different point. Let's assume they had good prospect of success on this conflict point, but we have good prospects of success on the 194 point. It cancels out, and therefore, whichever way you look at it. So we implore this court then to say that if a person who was biased, such as the president, and who acted unreasonably, can escape the clutches of an adverse cost order, that's exactly why these parties do this. That's why they bring us back here. They say, spare the rod and spoil the child. So if the court at some stage, and we accept the issue of judicial restraint, but there must come a point where the court says this far and no further. We're not going to be abused day in, day out by people who should not even be here, trying to achieve what is unlawful by using the court just as a conduit pipe, of doing exactly what the court has said must not be done. So this is, with the greatest respect, the matter where on the merits, at least, there is no defense that has been mounted on any of the requirements. And this is the classical case where the court should grant. This is the reason why Section 18 was promulgated. Let me put it that way. This is exactly that reason, where there are exceptional circumstances, no harm to the other side, palpable harm to the one side. That's what the legislature wanted to achieve. Let's not legislation. Yeah. Okay. Well, for what it's worth, since there was mention of witnesses, I'm reminded to point out that we have made it clear in the affidavit that in terms of the Section 194 committee, there's only, I think, one and a half. There's a witness who needs to be cross-examined, and then another one who's going to talk about legal costs and so on. But there's basically half a witness, let's say two, so that I don't have to split hairs, that are left. So there's no suggestion that those witnesses would be intimidated. But really, as I say, all those things, they have their own recourses. So if there's a witness who's intimidated, they know what to do. They go to the police station or do whatever they need to do, or tell the chairperson of the committee. But we can't keep the public protector in the dungeon simply because there's some theoretical possibility of some unnamed witness being so-called intimidated. The nullity is a nullity. That nullity, which was the suspension, must be visited with nullness, which is voidness, and the fact that, quite frankly, we should all erase it from our collective memory as something that was an unfortunate event, but which has not happened. And the only way to do that is for the restoration of the status quo ante, in respect of which Section 90 of the Constitution is there, and there are all sorts of other avenues. So it's not for this court to try and prevent some theoretical things that we don't know. This court must simply apply the law. Section 18 has requirements. Have those requirements been met, yes or no? If they have been met, then the court must do that which Section 18 says must be done. And the court can be assured in that by the fact that there are safeguards which are in Section 18. Those safeguards, The first safeguard is the one we're debating here, which is the high standard of owners that the legislature has introduced. The second safeguard is the safeguard of automatic appeal. So they don't even have to do applications for leave to appeal in terms of Section 18.4. It's an automatic appeal. The third safeguard is something that's unprecedented in our law. I've never seen it in my entire life, where it says that that appeal must be heard as a matter of extreme urgency, not just urgency, extreme urgency. In other words, the court must stop everything. So those are the safeguards that will be that are available to the other side. But the public protector has no safeguard. Her only safeguard is the three justices sitting here, simply reiterating what they said so emphatically last week, which is that the suspension must be set aside. If Mr. Chabalala wanted me to say a point, then he's lost his his turn. The order should then be simple. Leave should be granted, and leave to execute and operationalize the order, and we'll accept that instead of being effective last week as the court intended, it will be effective when this order is granted. And with those, oh yes, I forgot the fourth safeguard, of course, is that they would have, whichever way, they would have achieved what they've been trying to do. Because the fourth safeguard is that pending that extremely urgent appeal, the judgment will be suspended. There's nothing we can do about that. It's unfair, it's unjust, it's oppressive, but that's what the law says as a safeguard for this kind of situation. It's cruel, actually, but as we say, it is what it is. Maybe one day someone will take Section 18.4 for constitutional scrutiny, but until then, that said situation will prevail. But what can we do? As God pleases. Oh, my junior was saying it looked like Justice Lekulen wanted to ask me a question.
No,
maybe he's having mercy on me. I wanted to bombard me.
No, I'm covered. Thank you.
As God pleases.
Thank you, Mr. Mbo.
I'm indebted to the court.
Thank you, Mr. Ngalwana.
My time says 12:31. I hope to be done, left to my own devices by 1800 hours. If that's acceptable.
That should be in order.
I'm sorry to disturb Mr. Nalan. I forgot you had given me a task during the break to speak to my learned colleagues. We had a small meeting, justices, and we agreed that we will stick to the times, but we thought that in fairness we should make it clear to the court that if those times are stuck to that we've agreed to, there'll be a spillover, a little spillover after 4 o'clock. But otherwise we'll stick to the collective times on this side. Thank you. Sorry.
All right. You may then proceed.
While we're dealing with housekeeping matters, I still have to check out with my hotels because we're asked to be excused after we have addressed our court. So I won't be here for replying purposes. Thank you. Justices, we address the issue of exceptional circumstances as well as the intricacies of the interplay between, on the one hand, Section 15 and Section 18 of the Superior Court Act, and on the other, Section 172 of the Constitution. I shall only be dealing with the exceptional circumstances aspect of our argument. Mr. Masuku will be dealing with the intricacies after I'm done. So the idea is to try and lay a foundation for him in order to pursue the 172.15 and 18 argument. Of course, I'm sure he will be guided by what Mr. Popo has already said. So he will tailor his argument accordingly. Hope I'm not throwing him under the bus and saying that. The Supreme Court of Appeal, in the Tebeza judgment, has set the standard for what exceptional circumstances are, and I shan't take you to that. The case is well known. It refers to various other judgments, both of the High Court and the Supreme Court of Appeal. I'll simply give you the citation as if you need it, but for the sake of completeness, it's 2017, Volume 5 of the South African Law Reports. Judgment begins at 402. It's the Supreme Court of Appeal judgment. The relevant excerpts begin at paragraph 34 until the end of that judgment. The application, Justices, is extraordinary. It is extraordinary for its novelty. Never before has the head of a Chapter 9 institution been in the crosshairs not only of the President of the country, but also of the main opposition party at the same time, for different reasons. The undisputed facts in this case demonstrate, with respect, a sitting president determined to go to the ends of the earth to protect himself politically, even if he trashes the Constitution in the process. And the nature of the trashing of the Constitution is, with respect, the interference with the functioning of the office of the Public Protector, which is a clear violation of Section 181, subsection 4 of the Constitution. The facts also show that the main opposition party that has consistently, from the very beginning, been opposed to the appointment of this head of a Chapter 9 institution, going to the ends of the earth to get rid of her. It is a coalition of the wounded, to borrow a phrase. A president wounded politically by a constitutional investigator who dares to investigate him on matters that happen also to form a basis for a criminal investigation by the police, and an impeachment process against him. It is of the president fell on the Public Protector the moment she announced publicly that she will be investigating the president, as this court has found in its judgment. The main opposition party, for its part, popped champagne in celebration of finally getting rid of the Public Protector. This is not some conjecture. You'll find it at page, if I need to refer there, page 139 of the record, paragraph 8. It's in the affidavit of General Bantu Bonke Olomisa. I think there's a middle name, Harrington. I didn't know that till I read that up. In an unprecedented twist of fate, the interests of the president and those of the main opposition party have coalesced to get rid of the head of a Chapter 9 institution who has been a thorn on their respective sides. That, Justices, makes this case extraordinary. And the circumstances that bring us here today equally extraordinary. Now, those whom we represent, driven by a commitment to their oath of office, to be faithful to the Republic of South Africa and to carry out their functions as members of the National Assembly, have decided they are not going to stand back. They are going to take up the cudgels on behalf of the people they represent to protect the Constitution and ensure that the executive is held accountable as he should be. This is clear from the facts. Only last week, this court, or the court as currently constituted, declared invalid the President's hurried suspension of the Public Protector, and it did so rightly on numerous grounds. One, that the suspension was retaliatory and unlawful. Two, the suspension was tainted by bias, not just any bias, but bias of a disqualifying kind. Three, the suspension was for an improper motive, as clearly demonstrated by the sequence of events that this court has detailed in its judgment. Four, that the President could not bring an unbiased mind to bear as he was conflicted when he suspended the applicant. This is what this court says in paragraph 157 of his judgment. Now, in reaching this conclusion, this court was informed by the sequence of events to which I've just referred. It is very important to go back there, and I won't dwell on it. It is this court that made that judgment, so I needn't read it back to them. But for emphasis purposes, let's remind ourselves that it was on the 7th of June, 2022, that the applicant informed the President in writing that she had decided to investigate the Pala scandal issue after a complaint had been lodged by one of our clients, the ATM. On that same day, the applicant dispatched some 31 questions. Well, they're not really 31, they numbered and requested him to give answers within 14 days. The following day, the 8th of June, the applicant made that public announcement, which proved to be the kiss of death, that she had decided to investigate the President on the Pala farm incidents. Then the very next day, the 9th of June, the President suspends the applicant. The following day, the 10th of June, the full bench in this court renders a judgment in relation to an interdict application that had been sought by the applicant to stop the President from suspending her. Now, let's remind ourselves, take a step back. The invitation by the President to the Public Protector to give reasons why, or to make representations to him about why he shouldn't suspend her, go back a few months in March. Now, based on this sequence of events, the full court concluded, rightly with respect, that the President's suspension of the applicant was triggered by her decision to investigate on the Pala farm incident. And it's not just that. The link between the facts that inform that investigation is important to the fact that those same facts are the facts that inform the criminal complaint to the police, as well as the impeachment processes or process against the president. I understand from yesterday that a panel has not been set up, so it is something that is in motion. This, justices, is the context in which the president's suspension of the applicant must be seen. It is the context in which this court set aside that suspension and did so with immediate effect, granting a just and equitable order. This is the context in which this court must determine the applicant's application. And this is the context that provides clear, exceptional circumstances. I want briefly to take you to the record, because this is very important for exceptional circumstances purposes. But before doing that, let me say this. If the removal by a sitting president of the head of a constitutional institution for daring to investigate on serious allegations, which, as I say, also inform a criminal investigation and impeachment process, if that conduct does not constitute exceptional circumstances in an application intended to reverse that perverse result, then justices, South Africans and the South African legal system and justice system is on a hiding for nothing. We will be deluding ourselves for believing that we live in a constitutional democracy. In an old democracy such as the United States, for example, a president lost an election for the sort of thing that the president of South Africa is accused of. A criminal violation of the Constitution. And unlike in this case, no court, as I understand it, had found that that president had breached the Constitution. Another president in the United States was forced to resign for breaching the Constitution. Instead, in this case, or in our country, our president gets cheered on by a main opposition party for interfering with the functioning of a Chapter 9 institution by removing a public protector shortly after she makes an announcement that she's investigating the president. That is an exceptional circumstance. So we say the facts in this case bristle with exceptional circumstances. The Constitutional Court characterized this sort of conduct, of which the president is being investigated, as theft. Theft of the power that was vested by the people in the president. Mr. Popo has already referred to the UDF judgment, and I've given you the citation. Well, he has given you also the correct citation. Now, how did the president know that he was free at the time that he did it? How did he know that he was now unshackled to exercise his power to suspend the public protector at the time that he did, before the judgment of the full bench was publicly announced? This is where the record becomes important. The Pan-African National, the PAC, Pan-Africanist Congress Party, which we represent, believes that he was informed of the outcome of that case. That is why it lodged a complaint with the Judge President of this division, who pointed it to the JSC processes. You'll recall this in its annexure BH3, I think. Oh, I don't think I know. Yeah, it's in my notes. It's BH3 on page 155 of the record. The complaint itself is at 155. The response by the Judge President is BH4 at 157. And this is how he concludes. Well, he says at 157, after receiving your letter, the same was forwarded, is writing back to the PAC. Same was forwarded to the judges who sat in the matter, namely Erasmus Dolamo Wille. Never known how to pronounce that. Well, apologies to the letter judge. As per my letter dated 23 August 2022, and enclosed here too, and he encloses. He attaches the responses from the members of that bench. Then he recounts what each of them says. And the conclusion is important. He concludes at 159 of the record by saying this. Finally, 159, almost half of the page down, a third of the way. He says, finally, may I draw your attention to Section 14 of the Judicial Service Act, Commission Act, which regulates complaints against judicial officers, which has been enclosed hereto for your ease of reference. Should you wish to take the matter further, your submission must be in writing in the form of an affidavit to the Judicial Service Commission. As the Judge President of this division, in response to a complaint about information about a judgment having come to the notice, that is the complaint. I'm not saying that's what happened. The complaint is that the President got to know of a judgment of the full bench involving whether he can suspend the Chapter 9 head, the head of a Chapter 9 institution or not. The President suspends her the day before that judgment comes out, and the Pan-Africanist Congress feels aggrieved, feels that there must be some skullduggery here. They lodge a complaint, ask for investigation to the Judge President, and the Judge President points him to the Judicial Service Commission. I missed one point, which is important to make, on the exceptional circumstances part. When the Judge President narrates his discussion of the issue with the judges, he makes mention of a WhatsApp with one of the judges. He says at page 158 of the record, he says, on 9 June 2022, that's the day on which the suspension was treated or happened, I received a WhatsApp message from Villa J that reads as follows. Tomorrow is stamped in George. Today, 2 question marks. I replied by saying, this is hilarious. So the complaint is not frivolous. by the PAC. That is what this points to. This is an exceptional circumstance. Before that incident, a member of the public somehow got to know of a decision of the Constitutional Court before it was made public, which also had a bearing on the relations between the president and this public protector, because it had to do with the Section 194 process which had been triggered. I don't want to get into a debate about whether the committee had started or not. I'll leave that to Mr. Fofu in another debate. But the point I make is one cannot divorce the application before the Constitutional Court, which I think was a rescission application, from the Section 194 processes in Parliament and the interdict application in this court. Those three are interrelated and have to be seen together in order to appreciate the exceptional circumstances that dog this case. So a certain Mr. Abramji, who, as far as I know, is neither a journalist nor, I don't know, I mean, it doesn't matter whether he was a journalist or not. I hear he's been called an analyst or something. To be safe, I'll call him a member of the public. Somehow gets to know of the decision of the Constitutional Court before it comes out, and alerts a member of one of the legal teams, I think for the, I'm not sure, Speaker or Democratic Alliance, one of the two, the Speaker, about the outcome of that judgment. The question is why? What's his interest in this? How did that information get to a member of the public from the Constitutional Court? To this day, we don't know that. There was an investigation which was not a JSC, as I understand it, investigation, which didn't answer the question, how did this happen? These are questions that relate to the exceptional circumstances in this case. By the way, you'll find this, I don't want to be accused of arguing outside the papers. This is a paragraph 144, paragraph 19 of
is it page 1?
144, Justice. Paragraph 19.
Thank you.
Now, the president and the main opposition party will have this court and the citizens of this country believe that all these are irrelevant coincidences. Well, those whom we represent do not share that, shall we, well, I'm not going to label it, do not share that thinking. Their role is to hold the president and the executive accountable, and that's exactly why they are here. Which is why, and this is the point I wanted to make earlier, Justice Luke, when I lamented the fact that the boat had sailed in relation to the intervention application. I hope I'm not seen as sneaking it sideways, but I just want to make one point on the role of those whom we represent. They see themselves as protecting the Constitution. And so for the acting public protector on an affidavit to accuse them of seeking to interfere with the processes of functioning of the constitutional institution in the form and shape of the office of the public protector is regrettable. I will put it no higher or lower than that. It is not an accusation that should have been made on affidavit. These facts provide exceptional circumstances within the meaning of Section 18 of the Superior Court. With 3 minutes to spare, that's my contribution to the debate on behalf of our client. And if I may just take soundings, maybe I've missed something. Unless there's anything else, Justices, those are our submissions on the exceptional circumstances side.
Thank you, Mr. Ngabana.
Thank you. Mr. Masuku will address us on the intricacies of 172 and Section 15 and 18 of the Superior Court. As the court.
Thank you, Mr. Masuku. How long do you think you're going to need?
I do promise to take less than 20 minutes if I'm permitted without any interruption. And it seems that's a possibility, judging from how smooth sailing my learned friend Mr. Ngalana's address went.
Well, you may proceed, but you can't promise that there should be interruptions.
The order granted in paragraph 187.6 was justified by the exceptional circumstances that Mr. Ngabana reflect an extraordinary constitutional dilemma triggered by the unconstitutional suspension of the public protector. But the real question that I tend to address the court on is what is the effect of an application for leave to appeal the orders, whether it's 187.6 or 187.5. The second related question is what is the effect of confirmation proceedings. We know the general principle that the operation and execution of a decision which is a subject matter of an application for leave to appeal is suspended pending the outcome of pending the decision of the application and appeal. But Section 18.2, which is really the nub of the submissions I intend to make, says that the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal, or an appeal is not suspended pending the decision of the application or appeal.
So that's Section 18.3.
18.2.
2.
I believe it's Section 18.2, my lord. It is Section 18.2. But so we have to look at the nature of the order that was granted in 187.6. Because 187.5, the order in paragraph 187.5, is the order that finds that there is the order which you would call an order of constitutional invalidity in respect of the conduct of the president, and therefore an order for which confirmation ought to take place in terms of Section 172(2)(a). But 187.6 is not an order of constitutional invalidity. It does not relate to the conduct of the president. It is what is classically regarded as an interlocutory order, given under the principle of just and equitable in Section 172 1B of the Constitution. Honorable Justices, an interlocutory order was defined in South Cape Corp Private Limited versus Engineering Management Services Private Limited, 1977, Volume 3, SA 534. It's an appellate division judgment at paragraph 549G. And in that judgment, an interlocutory order was defined as follows. It said, in a wide and general sense, the term interlocutory refers to all orders pronounced by the courts upon matters incidental to the main dispute, preparatory to or during the progress of the litigation. But orders of this kind are divided into two categories: those which have final and definitive effect on the main action, and those known the order in 187.6 is what you would call an interlocutory order, because it is an order that regulates the period between the time the judgment is given and the time that the Constitutional Court confirms the order of constitutional invalidity in 187.5 of the judgment.
Just so that I understand your submission. So what you are telling us is that that order is the sort of order that would not be suspended pending the appeal.
That is correct.
Yeah.
So I'm accepting what the public protector said about the need for bringing an application to enforce the order under Section 8, under Section 18. But the submission I'm making is that the public protector must go to work, because whether there is an application for to appeal or not, it is of a nature that does not have the effect of suspending 187.6 of the judgment of the judgment, because it falls within 18.2 of the Superior Court Act. But honorable justices, in the judgment, you do reflect on what the order that you believe would be necessary to give upon pronouncing the conduct of the president unconstitutional. And you said in 187, you said that that order has to be a just and equitable order, and that would fall under 172(1)(b). And I've made submission that that order, that is not an order of constitutional invalidity relating to the conduct of the president, but it's important for the court to reflect a bit more about what orders that are referred to as just and equitable, which are discretionary orders, what they intended to achieve. The first is that they regulate the period that it takes to confirm an order of constitutional invalidity. So they mitigate the effects of an order of constitutional invalidity. They are designed to avoid unnecessary disruption in governance or public affairs, especially where a constitutional invalidity order is granted in relation to legislation. They are also designed to ensure that fundamental rights are not affected by an order of constitutional invalidity. In fact, a just and equitable order must protect fundamental rights of persons who could be affected by an order of constitutional invalidity. And this takes me to why the order under 187.6 is an order that is not suspended by an application for leave to appeal in terms of 18.2. It is so because you would know from the provisions of 181 the responsibility of everyone in relation to Chapter 9 institutions. 181.2 says, these institutions are independent and subject only to the Constitution and the law, and they must be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. And of course, an order as this court has granted in paragraph 187.6 is an order that
Justices, we have to then turn to the first of those two subjects, and that is just in terms of locating Section 172 of the Constitution. We've heard much debate in the course of this meeting about what the power is, what were the grounds on which it was invalidated, and all of that has seemed to be an endeavor to prove to this court that it was not conduct of the President that we're talking about. in the Constitution. The third one that deals with the decision is the one at paragraph 12.5 of our argument, and that is the decision of the President in relation to an increase in annual remuneration of magistrates and regional court presidents. And that decision too was taken by the President, and it was found to have been subject to confirmation by the Constitutional Court. So, if I could pause here for a moment, Justices, what those cases put us in three of those instances is a presidential decision taken in terms of an empowering provision. And in all three instances, the decision is found to amount to presidential conduct and is therefore subject to confirmation by the Constitution. The two other matters, or two other cases that we referred to, and that shows the breadth of the meaning of presidential conduct. The one deals with where the President entered into a settlement agreement. The other deals with